I'm very curious to see what the Supreme Court is going to have to say about all this.
And there is some hope that the Supreme Court is actually going to overturn this. Welcome back to Northern Perspective, everyone. I'm Cypher.
And I'm Fox. We have some very intriguing news when it comes to the release of the MP names as part of the NSICOP report. It turns out that there's a lot more people that want to hear those names, and there has been an ongoing court battle over whether or not the members of that committee are allowed to release the names to the public.
Let's take a look. So this is an article that was published in the National Post on June 14th, and the title of that report states, "Lawsuit seeks immunity for NSICOP members if they reveal top-secret intel on foreign collaborators. Two rulings have new and significant implications for revealing classified information following NSICOP's report released on June 3rd. Could a member of Intelligence Oversight Committee claim parliamentary privilege to reveal classified intelligence in the House of Commons and be immune from prosecution? That's a question that could be headed to the Supreme Court of Canada. The issue has surely never been more relevant than now, given the release last week of the committee's bombshell foreign interference report alleging that some parliamentarians wittingly conspired with other governments. In a late April ruling that largely went unnoticed, the Ontario Court of Appeal ruled that legislators on the National Security and Intelligence Committee of Parliamentary, or NSICOP, cannot claim parliamentary immunity if they improperly reveal state secrets obtained through their work. The ruling has new and significant implications for the ongoing debate about revealing classified information following NSICOP's report released on June 3rd. The case has pit national security against the vital principle of parliamentary privilege in a Westminster-style democracy, which gives legislators immunity for actions undertaken as part of their duties. But the issue may be far from closed. As Lakehead University constitutional law professor Ryan Alford said, he plans on asking the country's top court to hear his appeal of the decision. In April, a panel of 3 appeal court judges ruled that Parliament was within its rights when it included a clause in the NSICOP Act that excludes legislators on the committee from parliamentary immunity if they divulge sensitive information without proper authority.
So what does that all mean?
So the interesting thing about this is that there was an initial lawsuit brought, and the initial court that heard it, the Superior Court, ruled that it was unconstitutional to actually restrict parliamentary privilege so that members of the NSICOP committee would be able to talk about certain things. Now, the government would have appealed that, and then that would have gone to the appeals court, at which point this latest decision was rendered, meaning that the judges in this ruling stated that the parliamentary privilege could be restricted. So we find that interesting because that means that Trudeau and the government of Canada believe that under no circumstances are the parliamentarians, as part of NSICOP, allowed to divulge certain information. Now, Ryan Alford, who's the professor at Lakehead, obviously thinks that they are. And I think the whole point of the initial part of this article is arguing that given what was released in the NSICOP report, that there's potentially, we don't know, but there's potentially active parliamentarians that are collaborating with foreign governments and possibly releasing state secrets or doing favors or whatever else that we can't see as part of this report, that they should be named. And I don't disagree. Some people would say, well, what about due process? Well, hello, people are suspended with admin leave all the time in private companies and in government when there's investigations going on. You see it in as part of police internal affairs investigations, RCMP internal affairs investigations. You're seeing it with Cameron McDonald and Tony Utano right now within the government. So their names are obviously released. They're facing administrative leave. They're being prevented from actually doing their job until they get to the bottom of an investigation. If anything, parliamentarians, members of parliament and senators should be held to even more of a strict standard because they are actively engaging with the governing of our country. So yes, absolutely, the public deserves to hear these names because, in effect, we are their boss.
Well, and we're the ones that put them there. That's right.
Right, so we deserve to know what our employees are doing. That's what we believe. Continuing on.
That could include, for example, revealing in the House of Commons which parliamentarians are suspected by intelligence agencies of having wittingly aided a foreign government contrary to the interests of Canada. The appeal court conceded that the exclusion contained within the NSICOP Act, quote, does limit the right to free speech and debate within Parliament, end quote, but that it wasn't unconstitutional. Quote, that limitation stops far short of anything approaching a constitutional renovation or an embargo on parliamentary oversight of matters pertaining to national security, end quote, the panel wrote. Quote, put bluntly, a committee member who improperly reveals information protected by the Security Information Act in Parliament or in a committee of Parliament can go to jail for the statements, end quote, the ruling reads. NSICOP is composed of MPs and senators of all political stripes and was established in 2017 to provide parliamentary oversight to Canada's intelligence agencies and departments. Under the Security of Information Act, or SOIA, the federal espionage law, individuals with certain levels of security clearances face up to 14 years of prison if they share classified information without authority.
But the appeals court's ruling reverses a diametrically opposite decision 2 years previous by the Ontario Superior Court in a case brought forward by Alford. The Ontario Superior Court in 2022 struck down the section of the NSICOP Act that excluded members from claiming immunity from prosecution if they improperly shared state secrets, ruling that it, quote, exceeds Parliament's authority. Now, this is just a conspiracy theory of mine, but I find it interesting. The reason why I find it interesting is in 2022, the Superior Court struck down this specific section in the NSICOP Act that, let's say this report was released today, they would be allowed to actually say the names. Now, after that, and 2023, when everything blew up about foreign interference, you saw Trudeau fighting tooth and nail in order to prevent a public inquiry from happening. And he may have also been very careful as to what he was sharing with the NSICOP report. And he was afraid of that up until the point where he said, okay, well, the public inquiry can start in 2024. And the actual hearings began in March and April, and this decision to overturn that part of the act occurred in April. Now, all of a sudden, NSICOP releases this report and they can't say anything.
Yeah, I would ordinarily say, this is just coincidence, it's no big deal, whatever. I don't believe in coincidence anymore.
Not when it comes to Trudeau.
Not when it comes to Trudeau. This is very suspicious to me.
So it's a little bizarre that shortly after the Court of Appeals actually overturned the original ruling, thereby, reinstituting this part of the act that would put people in jail if they were to release any information, that this report comes out and the public inquiry is in full swing. So I think that's very interesting. Now, Mr. Alford, he needs to be applauded because he has seen a problem with that and a problem with the initial part of the act to the point where he argued it in court and won. And now he's going to continue arguing it up to the Supreme Court. So let's continue. The only way to enact the parliamentary privilege exclusion, Justice John Frageot wrote, would be to amend the Constitution. The disagreement between the Superior and Appeal Court and the novel issue raised by this case is why Alford plans on bringing the case to the Supreme Court of Canada. He told National Post he expects to apply for leave to appeal to the country's top court early next week. Quote, "Let's be clear. If the Supreme Court denies leave here, it would be really a scandal to be treated as such, given the clear public importance of what's been raised," end quote, Alford said. In his application to the Supreme Court obtained by National Post, Alford argued that the case is about, quote, "every Canadian's right to have representatives who may speak freely," end quote. Quote, "Certain members of Parliament are now deprived of their freedom of speech and debate in Parliament owing to a federal statute that expressly removes their parliamentary immunity and thereby subjects them up to 14 years in prison for exercising their freedom of speech and debate in a manner that the executive may deem problematic," end quote. So this is an interesting one in that the original case was brought and won at the Superior Court level, then it was appealed, and then that ruling was overturned at the appeals court level. So naturally, you have to go for 2 out of 3 and see who wins. So that's what Alford is doing. So he really needs to be applauded for taking up this case, because it's important that MPs be able to say what they need to without fear of going to jail.
Yeah, so now this is going to the Supreme Court of Canada to determine whether or not it is constitutional or unconstitutional for these MPs to essentially have their freedom of speech taken away in the House, and whether it's okay for them to face up to 14 years in prison if they talk about what they've learned through NSICOP. This essentially creates 2 different classes of MPs. Those who can go to jail for exercising their parliamentary privilege or attempting to exercise their parliamentary privilege, because as we've read, it's not covered in cases of parliamentarians who are part of NSICOP and then release information in the House. And then those MPs that can say whatever they want, whenever they want. So it really seems unconstitutional to me. I'm very curious to see what the Supreme Court is going to have to say about all this.
And there is some hope that the Supreme Court is actually going to overturn this, because they've already overturned the Emergencies Act, recall. So they're not afraid to make this government look bad, when that's a really good thing when it comes to the justice system in Canada, because that's the one thing that we still are holding on to that can actually push back against these unconstitutional laws and unconstitutional practices that the Liberal government has actually put into place. And I'm really glad that the National Post actually covered this, because obviously no other mainstream media is actually keeping track of this. And this is absolutely vital and pertinent as to what is going on in Parliament when it comes to this NSICOP report, and what Canadians, in I think every Canadian's opinion, have a democratic right to know. What is going on with the people that we elect, and are they acting in our best interests?
Canadians deserve to know what our elected officials are up to, and who may be aiding them, and who may be participating with foreign agents to interfere in our elections.